My name is Owen Calloway. I spent 26 years working oil rigs off the Gulf Coast, and the last 11 of those I spent as Chief Safety and Compliance Officer for Meridian Energy Partners, a mid-sized upstream company based out of Houston, Texas. We weren't Exxon. We weren't Chevron. But we were profitable. We were respected, and for a long time, I genuinely believed I was part of something worth building. I'm telling you this story now because my buddy Ray, we worked a platform together back in 2003, before either of us had gray in our hair. He asked me last Thanksgiving what I'd learned from all of it. We were sitting on his back porch in Beaumont, and I had a beer in my hand, and I thought about it for a long time before I answered. I told him, the most dangerous man in any organization isn't the incompetent one. It's the incompetent one who doesn't know it yet. He laughed. Then I told him the whole story, and he stopped laughing. Meridian Energy Partners was founded by a man named Arthur Weston. Old Arthur built the company the hard way, starting in the 1980s with 2 leased platforms and a handshake deal with the Louisiana Pipeline Co-op. By the time I joined in 2014, Meridian had 17 active wells, a compliance record that the EPA had cited as a regional benchmark, and a culture of doing things right even when doing them fast would have been cheaper. Arthur wasn't easy to work for. He expected more than you thought you had, but he was fair, and he knew the industry down to the dirt under his fingernails. I'd been brought in specifically to oversee our environmental compliance division. My background was a combination of offshore operations and regulatory work. I'd spent 4 years before Meridian doing compliance consulting for the Bureau of Safety and Environmental Enforcement. I knew the federal permitting system the way some people know their own kitchen. I could find a buried clause in a Title V permit application the way a plumber finds a leak, by feel, by instinct, after years of just knowing where things go wrong. My team and I had spent the better part of 3 years developing something we called the Meridian Environmental Compliance Framework, MECF for short. It wasn't glamorous. It was spreadsheets and site audits and about 9,000 hours of coordination with state and federal regulators across Texas, Louisiana, and offshore federal waters. But what we built was significant. The MECF was the structural backbone that allowed Meridian to maintain its operating licenses across all 17 wells simultaneously. Without it, each well would have had to navigate its own permit renewals independently, and in the Gulf, that's not just slow, it's catastrophically expensive. Here's the part that matters for this story. The MECF also included something I'd negotiated quietly over 18 months, a pre-approval framework with the EPA's Gulf Coast Regional Office. It was a memorandum of understanding, really, that gave Meridian expedited review status on future permit modifications. It wasn't public. It wasn't in any press release. It sat in a 3-ring binder in my office and in a secured folder on our server, and the only people who fully understood what it meant were me, my deputy Sandra, and Arthur Weston himself. That pre-approval framework was the reason a consortium of investors out of Dallas, a group called Pinnacle Basin Resources, had been in serious talks with Meridian about a joint venture. They wanted to expand into 3 new offshore blocks that had just come open for lease in the Western Gulf. To do that, they needed expedited permitting. To get expedited permitting without starting from scratch, which would take 3 to 4 years minimum, they needed our framework. The deal on the table was structured around a licensing agreement valued, conservatively, at $68 million. If everything closed, my contract included a performance bonus of $112,000 that would vest upon finalization. I want to be precise about that timeline because it matters. The vesting date was set for the last business day of October. My bonus and a contractual transfer of certain licensing rights were both tied to that date. Arthur's son started at the company in early September. His name was Preston Weston, 29 years old, an MBA from SMU, and approximately 4 months of experience working at a private equity firm in Dallas before Arthur decided it was time to bring him into the family business. I have nothing personal against Preston as a human being. I'm sure he was fine at whatever he did in Dallas, but he walked into Meridian with the specific energy of a man who believed that understanding a business conceptually was the same as understanding it operationally. He sat in on my compliance briefings for about 2 weeks. He asked questions that were sometimes thoughtful and sometimes revealed that he'd retained almost nothing from the previous meeting. He referred to our EPA pre-approval framework as the regulatory shortcut thing in front of a room full of engineers, which told me everything I needed to know about how much of the substance had actually landed. Arthur gave him the title of Executive Vice President of Operations, which meant, in theory, he had authority over my division. I tried to work with him. I genuinely did. I brought him into every major meeting. I put together a briefing document specifically designed to help him understand the MICF and why the Pinnacle Basin deal depended on it. I flagged, clearly, in writing, that the vesting timeline for the licensing transfer was non-negotiable and tied to regulatory calendar windows that could not be moved. He thanked me for the document and asked if I could summarize it in a shorter version. I summarized it. He thanked me for that too. The first week of October, Preston called me into a conference room. He had a legal pad in front of him and the particular expression of someone who has made a decision and is now informing you of it, not discussing it. He said the company was restructuring the compliance division. They were going to bring in an outside firm, a consulting group out of Atlanta that had done work for another energy company Preston knew from Dallas. He said the transition would be immediate and that my position was being eliminated. I remember the specific quality of the silence in that room. The hum of the air conditioning. The way the afternoon light came through the blinds in stripes across the table. I asked him if Arthur was aware of this decision. He said his father had given him authority over operational decisions and that this was an operational decision. I asked him specifically about the Pinnacle Basin vesting date, 3 weeks out, and whether he understood what my departure would mean for that timeline. He said the outside firm would handle the transition and that he was confident they could get up to speed quickly. I looked at him for a moment. Then I said, very carefully, that I needed him to be certain he'd reviewed my full contract, including the sections relating to the EPA pre-approval framework and the associated licensing rights. He told me not to make this harder than it needed to be. I cleaned out my office that afternoon. Security walked me to my car. I called Ray on the drive home and told him what happened, and he said some things about Preston that I won't repeat here. Here's what Preston didn't know, what I suspect he'd never actually read in my contract, because if he had, someone with any experience would have stopped him. The EPA pre-approval framework wasn't owned by Meridian outright. It had been developed partially under my name as the licensed compliance officer of record who had negotiated directly with the regional office. There was a clause in my employment contract, one I had specifically requested when I signed in 2014, and which Arthur had agreed to, that stipulated the full transfer of my regulatory rights and professional certifications associated with the MECF would occur upon completion of the performance period. That performance period ended on the last business day of October. I had been terminated on October 9th. The transfer had not yet occurred, which meant that when Pinnacle Basin's legal team did their due diligence review in preparation for closing, which they were scheduled to do in the 3rd week of October, they were going to find something unexpected. I didn't call anyone. I didn't reach out to Pinnacle Basin. I didn't contact the EPA. I just went home, made dinner, took my dog for a long walk through the neighborhood, and called my attorney the next morning to make sure I understood my own position correctly. My attorney confirmed what I already knew. I was under no obligation to facilitate any transition that hadn't been structured per the terms of my contract. The rights were mine until the vesting date had passed with the appropriate conditions met, conditions that now, given my termination, could not be met. I sat with that information for a few days. I want to be honest about what I felt during that time, because I think people assume in situations like this that the person who's been wronged is sitting there plotting and scheming. I wasn't. Mostly, I felt tired. I felt the particular exhaustion that comes from realizing that 11 years of careful, competent work could be undone by one person's impatience and arrogance. I felt angry in a quiet, settled way. Not the hot kind of angry that makes you do something stupid, but the cold kind that just sits in your chest. I walked my dog. I raked leaves in the front yard. I called my daughter, who was finishing her junior year at UT Austin, and she asked how I was doing, and I told her I was figuring some things out. And she said, "Dad, you always figure it out." And I don't mind admitting that I had to step outside after we hung up because I didn't want her to hear me struggling to keep my voice steady. The call came 17 days after my termination. It was Preston, not Arthur. Preston. The due diligence review had happened. Pinnacle Basin's attorneys had identified the discrepancy in the licensing rights. They had flagged it to Meridian's legal team, who had then, I imagine, had a very unpleasant conversation with Preston about exactly what he had done by terminating me when he did. Preston's voice on the phone had a different quality than it had in that conference room. The confidence was still there, technically, but it had the brittle texture of something that had been stressed past its tolerance. He said the company wanted to discuss a resolution. He said there might have been some miscommunication about the transition timeline. He said he was sure we could find a path forward that worked for everyone. I told him I'd be happy to have that conversation through my attorney. He paused. Then he said, and I want to be precise here because I want you to understand the specific nature of what he said. He said, "Owen, you have to understand, this deal is worth a lot of money to a lot of people. You don't want to be the reason it falls apart." I thought about my 11 years. I thought about the 18 months I'd spent negotiating that EPA framework, the phone calls, the site visits, the late nights cross-referencing permit language with Federal Register updates. I thought about the document I'd written specifically to help him understand why this timeline mattered, the document he'd asked me to summarize. I said, "Preston, I think you should talk to your father." Then I hung up. Arthur called me himself 2 days later. This was a different conversation entirely. Arthur Weston is many things, but he's not stupid, and he'd clearly spent the intervening time getting a full picture of what had happened. He didn't make excuses for Preston. He didn't ask me to pretend the situation was something other than what it was. He said simply that a serious mistake had been made, that he took responsibility for giving his son authority he wasn't ready for, and that he wanted to know if there was a path to resolution that I would consider. We talked for almost 2 hours. What we eventually agreed to was this: Meridian would honor the original vesting date terms, including my performance bonus, with an additional settlement for the wrongful termination. In exchange, I would facilitate a structured transition of the MECF licensing rights that gave Pinnacle Basin what they needed to close the deal. My attorney negotiated the specifics, and I'm not going to quote figures here, but I will say that I no longer need to worry about my daughter's tuition. The Pinnacle Basin deal closed in November. Meridian got their joint venture. Pinnacle got their expedited permitting pathway. And I got something I hadn't expected. Arthur called me on the day of closing, not to discuss business, but just to say he was sorry it had gone the way it did. He said I had built something real, and he was sorry his son hadn't understood that before he acted. I appreciated that call more than I probably let on. Preston, I heard later through people who were still at Meridian, was moved to a different role, something with less operational authority. I don't know the specifics, and I genuinely don't spend much time thinking about it. He's a young man who moved faster than his understanding could carry him, and that's a lesson most of us learn, one way or another. I hope he learned it without it costing him something he couldn't get back. The Atlanta consulting firm, I'm told, withdrew after the due diligence complications came to light. They apparently hadn't been briefed on what, exactly, they were being asked to take over. I have some sympathy for them. They were walking into a situation someone else had created without knowing how deep the water was. Ray, back on that porch in Beaumont, asked me what I would have done differently. I thought about it seriously, the way he deserved. I told him I would have made sure, much earlier in Preston's tenure, that Arthur himself had signed off in writing on any decision affecting the vesting timeline. I had assumed that my contract's language was protection enough, and it was, eventually. But the cost of eventually was 17 days of uncertainty, a wrongful termination on my record that had to be expunged, and a level of stress I wouldn't wish on anyone. The paperwork protects you, I told him. But you have to make sure the right people have read it. He nodded and handed me another beer. Here's the thing I keep coming back to. The thing that matters more to me than the bonus or the settlement or any of it? My daughter called me the week after everything was resolved. She'd heard some version of the story. Not all the details, but enough. She asked me why I hadn't fought back harder in the moment, why I hadn't made more noise when Preston fired me. I told her that sometimes the strongest position is the one where you don't have to make noise, where you've done the work, prepared correctly, and can afford to let the other person's mistake reveal itself. That fighting back in that moment would have made me look desperate and might have complicated the legal picture. That the patience wasn't weakness, it was strategy. She was quiet for a second. Then she said, "Okay, Dad, that actually makes sense. That's the part I'll remember longer than any of the rest of it. Not the settlement. Not the look on Preston's face when he called me and his confidence had gone brittle. Not even Arthur's apology, though that meant something to me. It's my daughter saying, that actually makes sense. Because at the end of it, that's what I was trying to show her. That you can go through something genuinely unfair and come out of it without losing who you are. That integrity isn't a luxury you set aside when things get hard. It's the thing you run toward, because it's the only asset no one can terminate you from." I'm Owen Calloway. I spent 26 years in the oil and gas business, and the last chapter of that time taught me more about contracts, patience, and what it means to actually know your work than the previous 25 combined. Take care of your paperwork, know what you own, and if someone underestimates what you've built, let them. They'll explain it to themselves eventually. People ask me sometimes if I feel like I won, like the whole thing was a competition, and I came out on top. I understand why they frame it that way. It's a cleaner story. But that's not actually how it felt. Standing in my driveway the afternoon security walked me to my car, watching the building get smaller. In the rearview mirror, after 11 years, what I felt was something quieter and harder than winning. I felt the full weight of having done everything right and still being standing there, alone, because someone hadn't read the paperwork. Here's what I've come to understand about situations like the one Preston created. Actions don't exist in isolation. Every decision a person makes inside a professional structure, especially one built on contracts, regulatory commitments, and relationships developed over years, sends ripples outward that eventually come back. Preston didn't fire me in a vacuum. He fired me inside a web of agreements, timelines, and legal obligations that he hadn't taken the time to understand. And the ripples from that decision came back to him with the full force of everything he'd ignored. That's not karma in any mystical sense. That's just how complex systems work. When you remove a load-bearing element without understanding what it's carrying, the structure doesn't politely wait for you to figure it out. It responds immediately and proportionally, and without any regard for your intentions. What I keep thinking about, though, what matters more to me than the settlement or Arthur's apology, is what the whole experience asked of me during those 17 days, because that's the part nobody sees. That's the part that doesn't make it into the story when you tell it at a barbecue. Those 17 days were a test of something I hadn't known I'd need to be tested on. It would have been so easy to make noise, to call Pinnacle Basin directly, to go to the media, to the EPA, to anyone who would listen, to turn my legitimate grievance into a spectacle. And part of me, the part that had spent 11 years building something careful and real and suddenly had it yanked away, that part wanted to, badly, but I didn't. And I want to be honest about why, because it wasn't nobility. It was clarity. I understood that the strength of my position came precisely from my restraint. The moment I started maneuvering aggressively, I would have introduced uncertainty into a situation where time and legal reality were already working in my favor. Intelligence, in that moment, meant knowing what not to do. That's the thing I'd want anyone to take from Owen Calloway's story. Not the dollars, not Preston's phone call when his voice had gone brittle. The thing worth taking is this. The work you do in the years before the crisis is the only thing that protects you during it. The framework I'd spent 18 months building, the contract clause I'd insisted on in 2014, the professional relationships I'd maintained with the EPA regional office, none of that felt like protection when I was negotiating it. It felt like diligence. It felt like doing the job right, until suddenly it was the only thing standing between me and losing everything I'd built. My daughter said it made sense. She's 22 and sharp, and I want her to carry this with her longer than I got to carry it myself. The people who endure aren't always the loudest, or the most aggressive, or the ones with the most authority. Sometimes they're just the ones who did the work, kept their word, and had the patience to let the truth land on its own schedule. Preston had authority. I had accuracy. And in the end, accuracy was worth $68 million. Take care of what you build. Know exactly what you own. And when someone decides you're replaceable without understanding what you actually do, let them make that discovery themselves. You won't have to explain it. The deal will.